Welcome, everybody, to The Lawyer Show. I am your lawyer, Jeremy Rosenthal. The Lawyer Show is our weekly Facebook podcast for lawyers, about lawyers, with lawyers, to give everybody out there an idea of how lawyers think, what we do, what we say when only Facebook Nation is watching and our 2 or 3 fans. And what we want to do is we want to show everybody that you know what it's like essentially to be stripped of all your feelings, all of your humanity, and to show people that whatever you may think of lawyers, it's actually worse. Things are actually far worse than you think. Your lawyer cares far less about your issues and your problems and is really just trying to monetize them in a way, and how we can effectively do that. Some people have accused me of having a heart. They just don't know me. My guest today, I think he's a few years younger than me, but he may have a heart left. I don't know. Hopefully not. I've been working with him for a long time now. We have been doing our best to try to desensitize him to human feelings and emotions, get him to think more like a lawyer and be more like a lawyer. Sometimes I feel like he's on his way. Other times he has emotions and feelings and thoughts that, you know, the rest of us frown upon. His name is Kyle Therrian. Kyle does criminal work as I do. Kyle is my law partner at Rosenthal Kalabus Therrian. Kyle is kind of what I like to call a lawyer, whereas I'm talking to people, I'm on the phone, sometimes yelling, sometimes screaming. Kyle's reading things, and he's in the books. And Kyle, his main area of practice, he does anything and everything that the rest of the lawyers in our office does, including trying cases. But Kyle really heavily focuses on appeals. And so we're going to talk about, if we want to talk about heartless and soulless areas of the law, there's no better place to start than appeals. Kyle Therrian, introduce yourself to JP, Kathy, and the crew nation.
Well, thank you, Jeremy. Thanks for having me.
We can't hear you, Kyle. Speak up and grab the microphone.
What a wonderful introduction. Thank you. I appreciate it.
No mercy.
Yeah, like Jeremy said, I've been working with Jeremy for 10 years. He's my law sensei.
You can do better than that. Come on.
He brought me up, and he is. He's my law sensei. That's what we'll leave it at. You're my law sensei.
No, we agreed that this would be better. We agreed that this would be your compliments of me were to last at least 2 minutes. So go. You've got some time.
You're handsome. I like your glasses. You have good ideas.
Some of them.
And Jeremy, you're fantastic.
I'm
lawyer.
kidding.
You're a fantastic. No, how much more time do we have?
I don't know. Is it another minute and 20 seconds of him complimenting me? Okay, so let's talk about Kyle Therrian, the human, first, and how you have molted to become this super bad ass appellate guru. Because people don't appreciate this, but Kyle is kind of a big deal. Kyle does his appellate practice is, I mean, you are the one who briefs all of the lawyers in the state. You send out an email on a weekly basis, bi-weekly basis?
Monthly basis.
Monthly basis. Shows how often I read it. It doesn't have enough pictures for me. And the font is too small. We've talked about this. I need at least 24-point font. You insist on this 14. Or
14 is the standard font that the Texas Rules of Appellate Procedure.
I read about those once.
Yes.
Second year of law. Anyway, but Kyle's the one who briefs all the lawyers across the state on case law updates, because the Texas is we have a lot of courts here. The courts say a lot of different things. But let's talk again, trying to shift the focus back to Kyle Therrian. Talk about your rise to greatness.
Oh, where to start? No, as a young lawyer, you come out of law school just trying to show the world that you can be a lawyer. You don't really necessarily know what exactly that means. You watch other lawyers do things and you try to emulate them. There's certain, especially as a criminal defense lawyer, a certain kind of a machismo. I got to go try cases. I've got to get in the courtroom, and I've got to, duke it out with the state of Texas and defend my client, in jury trials. And I partook in those, those exercises, and I certainly still do. But I think probably most lawyers are a little bit obsessive compulsive, and where I kind of directed that energy as I started to kind of get comfortable as a lawyer is in briefing things and kind of obsessing about the law and digging out case law, which I'm sure we'll talk about here in a minute, and the significance of case law. But digging out case law, digging out constitutional law, and presenting it to judges and doing it in a way that really just kind of outworks and outperforms your opponent. And as I started to do that, people in the community, the legal community, start to kind of see that, maybe you're a little bit of a bookworm, maybe you kind of, dealt with the issue before, and over time, and as you kind of grow as a lawyer, you're kind of collaborating with lawyers in your office, or even just other lawyers in the courthouse, and I started to kind of like the element of being a resource for other people, being a resource for my colleagues, being a resource in our office, and I just kind of ran with that. And the natural kind of industry or the niche of just kind of being the bookworm lawyer is the appellate lawyer, is the guy or the girl who just kind of stays up to date on case law and is appealing decisions and just kind of knows kind of those nooks and crannies of the law, and to kind of relate that back to what we do at our firm. I think that provides a real good resource for clients, because as lawyers are their reputation, and they having the reputation, the courtroom with the judge as somebody who knows what they're talking about, maybe introducing some advocacy to the question, but certainly knows what they're talking about. You can go in there with some credibility and some actually be a resource for the judge as well to some extent. So that's where I've at least recently gravitated towards is appellate practice.
Let's talk to let's talk to everybody and tell everybody because a lot of our viewers are not lawyers. The show is again billed as for for anybody and everybody to watch. Particularly, I think a lot of non-lawyers kind of need to see the depravity of what it is we do on a daily basis. Tell them what a brief is, because that's a term that gets thrown around. It's obvious to you and me. It's not even the first day or week of law school where we talk about briefs or briefing, but I don't know that everybody at home knows what a brief is. What's a legal brief?
So at least in the context of what we do as criminal lawyers, questions arise in the courtroom about whether your opponent can say a particular thing during trial about your client, whether they can use a certain witness, whether they can call your high school principal to say that you're always in trouble, or whether you can call your church pastor to say he's a holy person that has always helped out at the church, or whether the Constitution was violated in any particular way in the investigation of a case. Those issues are very nuanced. Our founding fathers, whether those be the U.S. Constitution or the Texas Constitution.
I think the correct term is the framers.
The framers, yes.
The gender-neutral term would be framers. That's what I prefer to use. That's just me. Keep going.
Yes. They provide us a document that is just it's limited, and then what we get is case law and opinions written by higher courts that explain kind of the nooks and crannies of how it should be implemented. So when we have an issue in court and we expect that the judge might not have kind of the depth of knowledge because of how much has been written about a particular topic, we do a brief. We write out a document that says, this is the issue that we expect to be dealing with in this case. This is our position on the law, and this is what the law says. Here's kind of the gray areas, what we think about how the gray areas apply, and we apply it to the facts of the particular case as we expect them to be. And then the judge has the benefit of having either read that in advance of any sort of arguments that are taking place in the courtroom, or reading it after arguments and delaying the ruling until he or she has had an opportunity to really just kind of delve in. So it's a lot of times issues can be decided on briefs. Sometimes the briefs point the judge where to start looking to kind of, drill down and make a decision on what type of evidence can be presented in a trial or a hearing.
So there's a couple of points to kind of pick up there. Number one is there's a certain I've got a friend of mine who has a very good point, although I would never admit this to their face. That says, a lawyer friend who says that one of the biggest obstacles to justice is laziness. And I think he's absolutely correct when he says that one of the biggest obstacles is just laziness. Now, there's laziness, and there's lack of resources and inability. So you take your average trial judge, right? And so what you do is you have an issue in front of the court, and your brief is something that they can chew on. Your brief is something that they can look at, that they can read. It's a resource for them. Here is, Judge, we know you know the law. Sometimes, with varying degrees of success depending on what your judge you're in front of. But, Judge, here's the law, and here's the specifics of this case, and here's the specifics of where this fits. And it's unrealistic to think that a judge who has 2,000 cases on their docket at any given time is going to really be able to focus on your specific issue. So it's really a way to kind of to cut out some of that inability or lack of resources, and in some instances laziness of the system, if you will, to try to hammer down and to get to that really, really finite point. And I think that's something that you do with that's the way that you advocate, particularly when you're doing legal briefs, and particularly when you're kind of drilling down like that. Do you find it that way? And to what degree do you think it would help, for example, for judges to have clerking and briefing attorneys? That's not an issue that we've necessarily talked about, because in the office we talk about really important things. We talk about what type of Christmas treats people get for us and what's in the snack room, things like that. What's in the refrigerator? What are we going to order for lunch, and how long of a drive is that? But talk about that issue. Talk about that. What can you do to kind of put the judge's eyes on the ball, so to speak?
So to speak to one of your first points, I've yet to meet personally a judge who I would consider lazy. I don't know if you've had a different experience. Certainly not here in Collin County, and we're blessed with some of the smartest legal minds to have.
As you can tell, as everybody, first off, you're watching JP Cathy and the Crew Network. You can see JP Cathy and the Crew Monday, Wednesday, Friday from 7:30 to 9. You're watching The Lawyer Show. We're on between noon and 1. One of Kyle's massive and quite impressive talents is to flatter and to compliment, and it's always appreciated here. I'm sure the judges in Collin County who watch this, if in fact there are any, I'm sure that they recognize that.
Okay, I've genuflected. Okay.
To them, yes.
Yes, thank you. What's the question?
I'd have to. Can we get the court reporter to reread the question?
What's the benefit to the judge of briefing. Yeah. So what I used to tell clients, I still do from time to time. A doctor goes to med school and learns about the human body, and there aren't other doctors that are kind of higher up in the doctor food chain changing how the human body works every month or every year. So you can pretty much learn everything you need to know about the human body to be a doctor. Lawyers go to law school to think like a lawyer, to figure out where the answers are, and to learn how to kind of keep up to date on some of the big issues and just how to think like a lawyer, how to be a lawyer. And so the volume of case law, the volume of law that our legislature passed, I mean, it's you can't really 100% stay on top of 100% of what's out there. You can do your best, but judges are busy. Judges have, especially in district court, at least here in Collin County, our general jurisdiction. So they're doing family law, they're doing criminal law, they're doing civil lawsuits, and so what it does is really points them to the kind of the brings it in from the 100-foot view to the millimeter view of the particular issue that you're dealing with in a case. As far as would judges benefit from like briefing clerks. So like a briefing clerk is somebody who just works for the judges in the courthouse, that the judge says, here's kind of what's being argued in front of me. I want you to go take a look at it and do some research and give me another memo and tell me who's right or who's more right here. As a judge, I think that'd be a fantastic resource. I think Tarrant County does something like that. I think Tarrant County has at least one kind of judicial research and briefing clerk. Certainly appellate court judges who decide appeals,
Mm-hmm.
they live by having briefing clerks and staff attorneys. As an appellate attorney,
and for federal courts too, if you look at the Supreme Court, I venture to guess that pretty much all of them in their background they've been a clerk for a judge. This is the track that they take. They're research attorneys first, and they're academics. In fact, that's one of the criticisms of some of your justices, is that not a lot of them see courtrooms. But anyway, go ahead. I cut you off. Yeah. I've never cut you off before, though.
No.
Not in the last whatever.
Yeah, no. Well, thank you. No. Did you cut me off? I didn't even notice. Yeah, no, I think that's a valuable resource. What the system we have in place right now is we have someone we call the Amicus here in Collin County.
Right.
Amicus is a Greek word? Greek for...
It's Latin.
Latin for friend of the court. Amicus is also what you call if an organization is going to write a brief to the Supreme Court that's not a party to the lawsuit but might have kind of a stake or particular viewpoint, that they'll write an amicus brief for the Supreme Court, or even our high courts here in Texas. And so we have there's a prosecutor who's not watching. He's definitely not watching.
There's no chance. He's a smart person. Yes. He's watching something far more enlightening than this is. But yeah,
he's the courthouse amicus. He a lot of times if you walk in as an attorney and you're not recognized by the judge on the same plane as this individual, if he's in there giving his opinion, he's the amicus.
I probably need to invite him on the show, and I don't know that he would accept an invitation. There's a lot of issues probably with prosecutors in general.
Would you guys talk about appeals?
I don't know, but okay. So to give everybody at home context, an amicus is a friend of is a term. It's a Latin term. It means a friend of the court. For example, probably the most clear-cut example I can give of an amicus is, let's say an issue is at the U.S. Supreme Court, and you've got party one over here, you've got party two over here, and let's say, for argument's sake, Exxon has a big stake in whatever because it's about oil and gas law. Well, they can file what's called an amicus brief. Everybody knows they're not a party, but everybody also knows that they have a stake in the matter, and they can file a third party, a brief that's just the law, and the judges can look at that, and they can look at it or not, and maybe they have a point and maybe they don't. We use the term for the courthouse amicus jokingly because he's really not. He's a prosecutor, but what we're kind of talking about here is it would be really nice for Collin County, for our judges, because they are overworked. And this is a resource question. I characterized it as laziness, and it's really not. In all sincerity, the vast majority of our judges are extremely hardworking, are extremely dedicated. They stand up for every lawyer in their courthouse, including us. But there's only so much that they can do. And when you walk in there with a white-hot issue that's really, really important to your client and you think may have statewide implications, it's really, really hard when that judge is just not familiar with the issue for reasons that you stated. There's just a million things for them to keep up with. There's one of the lawyers at the DA's office, at the Collin County DA's office, is an outstanding appellate lawyer, and he has a very, very great reputation that's well earned and deserved in the courthouse. And to his credit, the judges trust him in some instances to be kind of neutral, and so it's not uncommon for the DA's office to say things like, when we're in the middle of a heated argument about the law, it's not uncommon for them to say, well, our appellate says this, or our appellate says that, and the judge kind of, you get the idea that the judge sort of views that opinion as from on high. Oh, well, your appellate division says it, so it has to be true. Yeah. Well, that's not really an amicus. We joke about it as that.
He's the smartest guy in the courthouse when Jeremy's not there.
You're watching JP, Kathy, and the Crew Network. You can watch JP, Kathy, and the Crew between 7:30 and 9 Monday, Wednesday, Friday. This is The Lawyer Show. We're on between 12 and 1 every Thursday. My guest today is Kyle Therrian, who's scoring massive points with me, as if that does anybody any good. And we're talking today about case law. We're talking about appeals. Tell JP, Kathy, and the Crew Nation what an appeal is.
An appeal, you don't get to appeal unless you lose. I guess that's a good starting point. So appeal's not a great thing to be.
You can cross appeal, but the state can. But anyway, go ahead. There I go, not cutting you off again.
There you go. No, an appeal is, typically, and really appeals kind of break down into two categories. In the criminal world, you got your writs of habeas corpus, and you've got your direct appeals. An appeal, direct appeal is, and I have an analogy for, also my sensei of analogies over here. I don't know if you.
Is it sports related? Those make the best analogies.
It is sports related. Okay, something went wrong. Something went wrong. You're convicted. You're on probation, or even worse, you're going to prison. And that result, in your belief, got reached through a misapplication of the law. Maybe that high school principal got to come testify about the thing you did that was terrible 25 years ago, and you think the jury really just kind of was laser focused on that instead of what you did. An appeal, a direct appeal, is usually predicated or is based on a.
What does predicated mean in English?
Yeah, predicate. It's based on. It's based on it's based on a ruling that the trial judge made that you disagree with that would have changed everything, right? So my analogy there in an appeal is basically we take it to the next higher court to look at the ruling, to hear arguments and consider the multitude of cases that have interpreted the issue, and decide whether the trial judge got the decision right or not, whether if the judge got it wrong, whether that made any difference in the outcome of the case. So that's a direct appeal. And then a habeas is basically, a habeas is something went wrong kind of behind the scenes that the judge may not have been privy to, didn't make a ruling on, is just something that was kind of jacked up that happened that nobody really knew about, or maybe one side knew about, but it didn't really happen in the trial or the hearing. So my sports analogy, Jeremy, here we go. A direct appeal is whether the running back got across the goal line. We can plug that video in. We can watch it 16 different angles and see if the ball crossed that plane. A habeas is whether or not Tom Brady inflated the footballs in the locker room. Right? We can investigate that. We can see whether it happened.
I'm with you. Okay.
We can interview the guy who took the footballs from the locker room to the field. We can talk to all the parties involved, but those Fox cameras aren't going to capture the deflated football, the slightly deflated football that made so much of a difference. In the
yeah.
ballgame.
So it's the difference between instant replay, right? Something that happens in the game, something that we can all see that happens. Versus something that we have to develop more evidence of in the future to see if somebody cheated in the past. Right. And so a good way to think of it too is in court we have a court reporter, right? That court reporter is typing things down. They're writing things, and people file documents. They file things into the record. And what that develops is a bunch of paperwork that we can read, we can verify. We know who said what in the courtroom. We know what was filed. We know what the judge looked at that day. And that can be the subject of a direct appeal, right? An indirect appeal is, or a writ of habeas corpus, same thing. An indirect appeal is something that, 15 years ago we found out that this prosecutor hid evidence. 15 years ago we found out that we believed back then that burn patterns, for example, were valid science. Today the science has changed. It said something different, and now we have to go back and reevaluate.
Right. Yeah, that's probably the most common scenarios on a habeas, a collateral attack on a conviction, is like you see in Dallas County, a lot of DNA exonerations, for instance. That's where, at the time of the trial in the 80s or 70s or whenever, the conviction was based on a lot of eyewitness and a lot of circumstantial evidence linking the defendant to the murder, to the sexual assault, whatever the case may be. And that person's been sitting in prison for decades, and we're now to the point where DNA can do a lot of the crime solving, or really implicate another person sufficiently to say that person's actually innocent of this crime. We need to let them out, and we've actually gotten to a point in Texas where we compensate those people. Not nearly enough for spending decades in prison, but they oftentimes come out, with health insurance for the rest of their life and $1 million. So, not worth it by any means the what you give away to go to prison wrongfully, but certainly that's probably one of the most common scenarios that we see in writs of habeas corpus. The other probably being something that the prosecution did improper, hid evidence. It's probably the most common issue on what we call prosecutorial misconduct. We learned that evidence was hidden that could have made a difference for the defendant at trial.
Another big tripwire is ineffective assistance of counsel, whereby basically I got bad legal advice from my own lawyer. My lawyer told me that if we did 1, 2, and 3, 4, this would all be fine. Or, for instance, and another one is failure to investigate a claim, right? Failure to investigate a case. As criminal defense lawyers, we have an ethical duty as well as a legal duty to zealously advocate for our clients, and that includes conducting our own, to some degree, independent investigation of whatever case we could be handling, which also strains the system because if you take the instance of a public defender, for example, and you take a public defender in Dallas County, just by way of, again, by way of example, who's got 300 cases on their table, including sexual assault, including aggravated assault with a deadly weapon, including robberies and things like that, it is very taxing on that person to try to do independent investigations on each one. Yet, if they're not done, the person could come back years later and say, I was denied my constitutional right to effective assistance of counsel. And in fact, those claims are probably more prevalent than claims of prosecutorial misconduct or hiding evidence or things like that. But again, we're talking about the difference between a direct appeal and an indirect appeal. And let's take folks through a scenario, okay? Let's say watching the lawyer show between 12 and 1 on the JP and Kathy and the Crew network. Let's say somebody has a loved one who just either pled guilty or lost a case, went to trial and lost a case. Immediately what happens? What should that person do if they think they got screwed?
Okay, yeah. If they think something went wrong, if they I think the first starting point for something like that is consult with the attorney that you have. That obviously doesn't solve the problem of the attorney that you had wasn't up to snuff. But if you went through a trial and the attorney should be consulting with the client about the arguments that you're making and the motions that you're making and the objections. And so I think a real good kind of sit down with your attorney and really ask what do I have to an appeal and who do you recommend?
What's the deadline for somebody to appeal a trial or a guilty plea? In some instances, and you may not have a right to appeal a guilty plea. Let's just pretend for argument's sake that you do. What's your deadline?
You've got 30 days from the date that judgment is pronounced in open court, unless you file what's called a motion for new trial, which is a kind of a quick fix to what went wrong, bringing to the attention of the trial judge, hey, this happened, this went wrong, let's address it. In that case, you have 75 days from the day judgment was pronounced to file your appeal, notice of appeal. It's a super easy thing to do to file the notice of appeal. It's just announcing to the world, I want my appeal. You file it with the court, and you've protected your right to have an appeal.
Okay, and let's say somebody comes to you and says, I'm not happy with the trial result. What's the first thing that you do in their case?
I do the football analogy.
Okay. What's the second thing you do in the case?
Yeah, the first thing I'm going to do, I'm going to call that lawyer and talk about the trial. What happened? What's screwed up here? How many days was it? Right? Because you a lot of times have to pay for that record, and that record, the cost is based on how many pages you got. And just kind of soak up as much information as I can from the lawyer, because really appeals are not. We want our clients to be happy, and we want our clients to be engaged in the process. And in the trial court and in litigation in the trial court, clients and attorneys almost work as a team to kind of to mount the defense. On appeal, it's we're almost working in a laboratory. We got the results, and we're going to pick them apart and figure that out. So really, if anybody's working as a team in that regard, it's the trial attorney and the appellate attorney to kind of feed information on this is what happened, either on that record, which you'll get to see, or what might have happened behind the scenes that informs maybe the need for habeas relief for the.
So what you're looking at is when the person comes in, you're essentially asking, we need to see the game tape. And we know we can't see that game tape within the next 75 days because we're actually not talking about a game tape. We're talking about a record, right? And a lot of times there's additional evidence or additional arguments that need to be made or need to be preserved, right?
Right, absolutely. If I may, with an example, we one of the appeals I handled in 2019, we had a young man convicted after a juror the jury was struggling with what we call intent, or the culpable mental state, whether you meant to do it or you did it on accident or you did it recklessly or negligently. The jury was clearly struggling with intent. They had already found that the charged offense, that the defendant did it intentionally, was not proven beyond a reasonable doubt. So they are struggling between whether he did it recklessly or negligently, which is a very, very nuanced kind of, almost an unfair question to ask a jury, in my opinion. But they're struggling with that. And one of the jurors went home and printed about as much stuff as she possibly could find off of Google, and brought it back to the jury room, right? And I was appointed by the court to handle this appeal, and I luckily followed my usual procedure, contacted the lawyer and said, what went wrong here, if anything? And what I got was, boy, let me tell you about what the jury did. So
one of the jurors let it slip, right? I forget.
Well, yeah, in Collin County, the judges will let you go back and talk to any jurors interested in talking about the case afterwards. And so they went back there, and like URLs were written on the whiteboard. In the
right. And a jury trial too. A jury trial, just so you know, I mean, the whole system of a jury trial is designed to give the 12 jurors or 6 jurors in a misdemeanor case as pure and sanitized a view as they possibly can. It is very controlled as the law that they see, the facts that they see, and everything in between. And so to have a juror, just in layman's terms, print out from the Google machine all of the laws, which who knows where in the God's green earth they got them, right? I mean, these could be Connecticut laws. These could be laws in the former Soviet Union or outer Slobovia. We have no clue. It would be like having a surgery and just pouring dirt on the wound, and just have somebody just getting a kitchen utensil out of the kitchen, and let's cut with this thing. The degree of infection is just so mind-boggling that it's crazy to me. But anyway, so that was your issue here. Keep going.
So we file a motion for new trial, and you bring the jurors in, and you effectively make them regret that they were ever jurors. That's obviously it's something that the judicial system wants to try to avoid. The judicial system is very protective of jurors, but in this case, we had to kind of get to the bottom of, what'd you bring in there? How much did you talk about it? How could it have affected your decision?
Typically, jury service, there's a privilege, and judges can't really get into deliberations. There's a standard there because we don't want jurors to have to go through this. But when they don't, but the judge's orders to them, I mean, it's a judge's order. It's a signed written document. Thou shalt not drive by the scene of where this car accident happened or whatever. And they violate it, then they can get asked questions. But keep going.
It's probably the number one problem that you have with jurors. They're on appeals. Their decision making, their verdict is protected, near airtight. What they do in that room is private. But they do have certain rules of misconduct, that the things they can't do, right? They can't flip a coin. They can't.
And tell us about it.
Yeah, they can't. You can't Google. At this point, judges include in the written instructions, no Facebooking, no Googling, no, to stay off the internet. I think there's some judges probably in more rural places that collect all the phones before they go back there. And so that's a big no-no.
Judges even tell people not to talk to their spouse.
Right. Yeah. So, I forget why I was using this as an example, but
we were talking about a motion for new trial and developing an additional record.
Right. So that's an issue that certainly, if we hadn't seen it, would be kind of more of a collateral thing. But during that new trial period, you can file that motion for new trial and try to quickly get all that in the evidence, and then hopefully the trial judge will look at it and make a ruling and avoid all the appeal and say, you know what, this is such a this is such a problem that I don't think that the community, that the public would have faith in the outcome of this trial because of what happened, and so we need to do it over again.
Okay.
And if not, that's on your record. Take it up on appeal.
So you file your notice of appeal, you get the record of it, okay? Tell the jury, or tell the jury.
I'm being cross-examined now, folks.
Tell JP, Kathy, and the Crew Nation, our jury, tell them what an appellate brief is.
An appellate brief is just, I mean, that's your body of work. Before
Do you get a new? Is an appeal a new trial?
No, right? You're not. Well, it depends. There's my lawyer answer. It depends. The appellate brief, you're taking the rulings of the trial judge, and you are kind of dissecting the law for the appellate court and arguing how the trial judge got it wrong. And when the trial judge got it wrong, this piece of evidence was brought in, or this, what the prosecutor said in closing statements was so egregious that it polluted the jury's verdict, or so you're looking at a specific issue that isn't about necessarily whether you've done it, but how it might have influenced the jury in deciding whether you've done it, with the limited exception of what we call insufficiency of the evidence, which is the bane of trial or of appellate attorneys' existence, trying to explain to clients, yes, we can argue about the facts of the case, but you need to understand that it's not a relitigation. It's not a, I think it should have gone this way, and the jury disagreed. With insufficiency of the evidence, and here's kind of, I'm going to do my best on the law. The appellate court looks at all the evidence that was presented through the lens most favorable to what the jury did. Mm-hmm. So if person A said X and person B said Z, and the defense did just a real bang-up job showing why, Z is just stupid to believe. Mm-hmm. Usually the appellate court is going to say, you know what, that's the jury's decision to decide between X and Z, and we're reviewing to see if at least some evidence in support of what we call the elements of the offense, the things that the prosecution has to prove, at least some evidence that is competent, that some reasonable person could have believed to be true, is supporting that jury's verdict.
It's just very rare to have an appeals court to say, no, this jury just made the wrong choice here. An example that I give folks is this. So let's say you are on trial for theft, and the witnesses come to court and they say that you showed up and you punched somebody in the face and then you left. Well, what really got proven up is assault, not theft, right? Yeah. But let's say the judge just gave the jury the instructions that the state has to prove beyond a reasonable doubt that you're guilty of theft, and the jury just hated you so much that they said, well, whatever, we're convicting you, even though the evidence showed you committed assault, we're going to convict you of theft just because you suck so hard and whatever. In that instance, that's a question of legal sufficiency. In other words, the appellate court in that instance would take it away and say, no, state didn't prove it. We understand that nobody likes this guy, but the state didn't prove it here. Now, it's never quite that divergent. It's never quite the evidence shows this or that.
My pet issue right now, and just to kind of show you how very nuanced and nook and cranny type of issue insufficiency of the evidence is, I'm handling a case right now where the evidence showed that in a matter of 30 seconds, SWAT team raided a house, kicked in the door. They're all yelling and doing their SWAT team thing. They broke out windows simultaneously with kicking in the front door. It's what we call a no-knock warrant, right? They don't have to knock and announce who they are. And they even said, we're doing this for the element of surprise. It was quote unquote shock and awe is what we were doing and what we intended, so that we can protect ourselves, right? We felt if we went in there and we said police, well, we're going to be in a shootout instead of a search warrant. And so what had happened is as soon as they came in the house, the defendant, the person accused, pulled out a gun and pointed in their direction. And so for that conduct, he was charged with aggravated assault on a public servant, and essentially it's an elevated offense, a higher offense to commit an assault on a police officer, right? And an aggravated assault, just to kind of conceptualize an assault can occur if you just threaten somebody, right? And that's what what the theory was, is pointing a gun was a threat on a public servant, a police officer. And the jury in that case found that, implicitly by its verdict, found that the defendant, not beyond a reasonable doubt, was aware that it was police officers in his house, that it was the SWAT team. There was a burglary in the house just the week before. He was a little on edge, and so they had found that he just didn't have that knowledge. So what we were left with in that case, the facts as narrowed down by the jury's verdict, was that this young man had 12 men in military garb breaking out his windows, kicking in his door, and yelling. And in that circumstance, I think most Texans and probably most Americans would agree, yeah, I'm pulling my gun, and maybe I won't start shooting right away until I know exactly what's happening, but I'm gonna have that gun out pointed in the direction of the intrusion. And that jury was instructed that they could convict on those facts of just a regular assault, right? And what should have been submitted to the jury is really a self-defense, right? You can stand your ground in your house if you reasonably perceive that you have intruders in there. So that's kind of we've weaved some sufficiency of the evidence into that. Is that sufficient evidence to convict for assault where it's very clear the only interpretation of what happened was a gun was pulled for intruders? So that's I mean, a very kind of nuanced issue, and that's one of the rare times that I'd look at an issue and say I'd expect to maybe prevail on insufficiency of the evidence.
What's prevail mean in English? No, I'm kidding. You're watching JP Cathy and the Crew Network. You can watch JP Cathy and the Crew between 7:30 and 9, Monday, Wednesday, Fridays. You're watching The Lawyer Show. You can watch us between 12 and 1 every Thursday. I'm Jeremy Rosenthal, and today I am your lawyer along with Kyle Therrian. Today we are talking about appeals and appellate law.
And vocabulary.
And vocabulary.
Our mutual friend, John Hunter Smith, I tried a federal case with him once, and he talked to the jury afterwards, and I took a cross-examination or two. I took the state's expert. I was asking about that expert's opinion, and the jury said, you go tell that other lawyer we had to go look up what opine means.
Wow. Yeah, that's one. So, in a quick story, because, as Kyle mentioned, I am, in fact, his sensei. I remember Kyle's very first, can I tell this story, the very first jury trial?
If I say no.
I don't know.
Proceed. Yeah, you can proceed.
So Kyle, as you can tell, is very smart, and Kyle uses big words, and they kind of teach you in law school to really, they teach you in law school to not to speak down to a jury, but they teach you that jurors are not lawyers. To be
as our friend John Hunter would say, is a superior sumbitch.
I've never heard him. He only says that to you. I've never heard him say that. For good reason. I'm sure for a good reason, because it just wouldn't apply to me. Anyway, so in law school they teach you they teach you that not everybody's a lawyer, right? Not everybody sits in the library with their eyes bleeding for hours and hours and hours like Kyle does, and learn every nuance of every law. So we tend to be real, I don't know, eggheads. It is kind of what we are. But when we talk to actual humans who still have hearts, unlike us, that the practice of law turns you into probably some degree of a sociopath, I would suggest. But when you talk to folks like that, you have to be able to be relatable, and you have to be able to speak in languages that they talk about. So Kyle's very first trial, which resulted in a not guilty verdict, yes, I sat as what they call the second chair, which means I'm the lawyer sitting there next to him. I'm the world's worst second chair on the planet. It just goes without saying, because I'm bossy pants, I'm alpha E. I've tried a billion jury trials myself, and I just kind of feel like I want to be the lawyer sitting next to me, the prosecutor, probably the court reporter, probably the bailiff. I just kind of want to do it all. Anyway, so I'm sitting there kind of doing that and then elbowing people and no, say this, and it really sucks to have me as your second chair. Kyle, who wins the trial, we're having lunch at some point after the fact, or maybe after jury selection, and Kyle had mentioned to the jury the paradox of the Fifth Amendment, which I won't go into I don't even remember what the paradox of the Fifth Amendment was.
If I may, the paradox of the Fifth Amendment.
JP, Kathy, and the Crew Nation, though, understand they can handle this. They can handle more complex conversations.
Well, and here's my theory. This is Collin County, America. Most jurors that we get are college educated or even beyond. Our jurors are smart and they get it. And in that trial, Jeremy, I did another nerdy thing, and I quoted Benjamin Franklin.
I must have been sleeping. I would have okay.
It was, and it's probably attributed to a whole bunch of other people that I'd draw
you
your
had
ire
been
for quoting.
You had been preparing for this trial, to be fair, for 28 and a half years.
Right.
Okay.
Better that a 100 guilty men go free than one innocent man be made to suffer. That is a premise of our U.S. Constitution.
Also not gender neutral.
Well, it's the quote. But that is a premise. That is the premise behind presumption of innocence. That is the premise behind requiring the state to prove guilt beyond a reasonable doubt. And we talked about that in jury selection. And you know what got repeated back to me on that verdict? There was one juror that flipped everybody back to not guilty when they're back there ready to convict. He said, hold on. I think it's better that 100 guilty people be set free than one guilty person be made to suffer.
Which is not how not how every Collin County juror thinks, by the way.
Well, if you talk about the paradox of the Fifth Amendment, they might.
But what was the paradox of the Fifth Amendment again?
I don't know.
I told, and
over
lunch at Chipotle, I remember telling you,
Don't ever say that
you asked me how did I do, and I pulled out my 48 pages of notes, just from the first 20 minutes of your thing, and I just said, I think you did great, but don't ever effing talk about the paradox of the Fifth Amendment again.
Okay, if you don't testify,
this is the paradox.
If you don't testify, it's because you're hiding something. If you do testify and you make direct eye contact with the prosecutor, you're a little too aggressive. If you are making direct eye contact with your lawyer, you're searching for the answer. If you're making eye contact with the jury, you're selling it too hard. If you look up, you're thinking too hard about it. If you look down, you're ashamed and you're not telling the truth. So maybe you shouldn't testify, but if you don't testify, it's because you're hiding something. And I would get up there, and I would say I didn't do it, right? So that's the paradox.
Can I tell you? All right. So now we're going to get into. I don't know about these are not war stories, but this is how I would do it.
Can we? I'm sorry. Can we talk about you?
I told Kyle today, leading up to the lawyer show, when we were talking about what we should talk about, I told him this show is all about him today. Kyle's smarter than that. He knows it's all about me. I just wasn't expecting him to say that out loud, but that's fine because this is all about me, right? But yes, no, you're exactly right. And this is actually a very important concept I think that people at home need to understand. as to why we have the Fifth Amendment. And if I can elaborate for a moment, in my mind, the framers of the Constitution, every time you think about something that they have done, it's quite genius, really, in a lot of ways that we don't appreciate. The Fifth Amendment being a prime example of that, because the Fifth Amendment is what allows you to not testify or self-incriminate. Now, to give that context to a jury, what we say is, look, this is if I was going to put you on trial in North Korea, in Iran, in some third world country, here's how I would do it. I would put you in a room. I would put a bright spotlight on your face. I would ask you things that I already believe, and then I would look at your face to see how you react, okay? And at the end of it, I'm going to decide that you're guilty because that's how I already feel inside. That's my feelings. In America, we focus on evidence, right? And to your point,
Question. Why would the police arrest you if you're not guilty?
Well, again, you are a Collin County resident, so I would expect a question like that from you. But what you ask a jury is you have to phrase it correctly. Why would an innocent person not testify? And people kind of, scratch their heads. I'm not sure. And then I say, then you can ask a juror, well, how does an innocent person testify? What do they say? Well, what if they're crying, right? What if they look you in the eye? What if they don't look you in the eye? Just like you were saying, what if they look up? What if they look down? When was the last time, Mrs. Smith, Mr. Jones, that you waited 14 months to get a case to trial? That you stayed up every night of your life thinking about what you were going to say. And then what you get is the jurors disagree with one another on what somebody telling the truth looks like. There's actually a quote from Shakespeare, and see, now I'm going to turn into you and be a super egghead, right? I doth think he protests too much. I agree to disagree. I don't remember. Is that Hamlet?
Actually, I don't remember if it's he or she. This is your
shtick. My thing. Okay, so anyway, the point being is that I doth think they protest too much. Basically, the harder you try to look innocent, the more you're going to look guilty. That's why we focus on evidence in America. Anybody have a problem with focusing evidence on loving America, right? And you'll get a few people in the audience that just, anything you're guilty. I'm being told I have to wrap it up. The Lawyer Show could go on forever. In fact, sometimes I wish it would.
It should.
I agree completely. There was a whole lot that we didn't cover, Kyle.
We'll FaceTime.
Yes, I would enjoy that. Your generation invented the internet and Facebook, I'm told.
Thank you.
Is your generation to blame for all the problems and all the... No? Anything else you want to tell JP, Kathy, and the Crew Nation? There was a lot that I wrote out an outline.
I'll just say on the paradox of the Fifth Amendment, Jeremy is one of the best trial lawyers I've ever had the pleasure of watching try a case.
This is true.
It is true. I know that there's thousands of young lawyers watching the Lawyer Show. And my advice is you got to watch the pros do it, but you got to try it your way. Because juries look to sincerity and look to whether you believe in what's coming out of your mouth. So I'm an egghead. Paradox of the Fifth Amendment is what came out of my mouth, but I believed it.
There you go, being right again.
So and I probably just barely, but I won that one. So but yeah, and part of the reason Jeremy's so good is he does try cases his way, and so that's, for anybody who's listening that hasn't figured out their own way, figure it out. Do it your way.
You've got to be yourself because everybody else is taken. That's Will Rogers, I think. It's not Shakespeare. Anyway, that wraps it up for probably one of the more successful episodes of The Lawyer Show. We are going to be taking a Christmas holiday for the next 2 weeks, but we are going to be back aggressively, shamelessly, and in a far more depraved manner in 2021. Goodbye, everybody.